folks. I'm Chad Pinkerton. We're here talking about the Vegas shooting matter. I'm a mass tort lawyer. I'm handling about 1,500 cases in this litigation already. Tonight's topic is the litigation process. I get a lot of questions from clients and potential clients about just how does this work. So generally at the beginning, I'm just going to talk about how it works a little bit. First, there's lawsuits filed. There'll be a lot of lawsuits filed by different lawyers that represent different people. Then the main lawyers will come together and file a master complaint. There will be a steering committee put together that are going to be really the lawyers that work on the case. I'm on the steering committee. My partner's going to be on the steering committee. We're on the lead trial group. Next thing is about 30 days later or 20 days later, you have an answer from the defendants. That means they answer the lawsuit and they can express some differences of opinion or they can answer the claims. After that in Nevada, you have kind of this initial conference period where you conference with the lawyers on the other side and you conference with the court. Then there's this disclosure period that talks about, hey, we're going to tell you who our witnesses are and what our ideas about the case are. Then you move into full-blown discovery. During discovery, you get documents, you take depositions, you have arguments in court. After that, after you do the factual part of it, that's the fact witnesses, the people on the ground, witnesses, your clients, all those sorts of things, the people at MGM and Mandalay Bay that was a head of security, Mr. Campos will be deposed during that period. All those things happen in the discovery period. Then you move on to experts. These are the people that talk about the standards for security and venue safety. After that, you move towards the trial date, and then you have a trial. The trial in a case like this will take about a month, I would guess, maybe 6 weeks, could be 8 weeks, depending on the evidence. Usually the first trial after filing will be about 16 months to 18 months. So that's kind of the general process. Now I'm going to get into some questions and try to answer as many questions I can in a short period of time because I know everybody loses focus, just like me. Joey, what do you got?
All right, thank you, Chad. I do have a couple of questions for you. I'm also watching the Facebook live feed, so if you have questions at home that you would like to ask, you can pop it right here into the comment section, and I'll make sure I'll try to get to it for you. But to start off, I do have a couple of questions about the litigation process. Will this case be filed on an individual basis, or is this part of a class action lawsuit?
Okay, that's a great question, Joey. Mass tort versus class action, two very different processes. This is handled as a mass tort, meaning we have a lot of people that were victims, all right? The police report came out this past week that said there were 22,000 victims. Whoever was there was a victim. Whoever was there can have a claim in this lawsuit. So those are the people that will be able to express a complaint. But in a mass tort, everybody's claim is individualized. So your claim does not depend on anybody else's claim. If one group goes to trial and they lose, it doesn't affect your ability to go to trial and win, and vice versa. So everybody has the opportunity and the right to a trial. You have your individual damages based on what happened to you, your physical injuries and your emotional injuries. So that's what's great about a mass tort. Now, you need lawyers that will work it up individually. Many lawyers that get involved in these cases get a bunch of clients and really don't work the case. At my law firm, we have a database, we have fact sheets. Every case is individualized, damages, and factually individualized. That way, when MGM, Mandalay Bay, CSC, or Live Nation ask me about your case, I can tell them exactly everything about your case. That's why a good mass tort lawyer always individualizes it. What else, Joey?
All right, thank you for that. So will you keep us informed as to any details you discovered during the lawsuit, such as evidence against the defendants?
Okay, good question. So Joey's asking about the discovery process. Now, during the discovery process, and even before, we haven't filed an active suit that we're pursuing right now, but we're doing discovery every day. I mean, I've interviewed personally over 200 witnesses. I've talked to experts already. I'm involved in the case even before the litigation. So we will discover things. some of those things will come to light to the public. Generally, courts do not like you trying your case to the public, and it's really not to the benefit of the case. We should rely on a jury of 12 to decide the case, but really that outside influence from the lawyers would be fairly inappropriate. But things do come out because things are public. They're publicly filed documents. There are people that ask questions in the media, and things are released. For my clients, of course, I update my clients. We use an email system. We use a private correspondence system so that we can talk about the case, the progress of the case, what's happened in the case, and what we've learned in the case. Because the truth is, if you're not talking to your clients, you're not doing your job. You have to communicate with your clients. For instance, we send at least one email to our clients every week, either asking them to do something or updating them on the case. That's very, very important. I'm doing this tonight so people out there can understand the case and learn something about the case. All right, what's up, Joey?
All right, thank you. I actually do have a couple of questions here from the chat, and I do have one from Beverly. She asks, as a client who lives in New York State, does she have to be in court in person?
Okay, good question, Beverly. What you're asking is, I'm from a different state, and where do I have to go to handle this case? All right, this case is going to be filed and tried in Clark County, Nevada. That's where the case is going to be. Now, we know that people came from California, North Dakota, Arizona, New York State, Canada. We know that. So you're going to be involved in the case. The case will be in Nevada, but that doesn't mean you have to travel to Nevada to do various things. Usually a client doesn't have to do very much in a case like this. They have to give their lawyer some information. Then they may have to give a deposition. That means sit down with the other lawyers and tell your story under oath. But that's highly unlikely. 1% maybe of all the clients in this case will have their deposition taken. So likely you'll stay in New York and do nothing until trial. And if you're a trial plaintiff, you'll certainly have to do more. I can talk about that later, but most likely most people won't be trial plaintiffs, and then you will just stay at home, answer questions to your lawyer, maybe give a deposition, unlikely to ever have to travel to do anything. And usually if we do your deposition, we'll do that in New York or my office. What else?
Okay, Chad. Well, would the client have any say in the settlement process?
Okay, this is really important. Many lawyers just look over this. Many lawyers don't want you to know this. You have the absolute right to say yes or no to any settlement. The truth is, if you tell your lawyer no, they need to try your case. If you tell them, yes, I want this settlement, and the lawyer says, no, I don't want you to take it, the lawyer has to follow your instructions. There's a lot of things I do in litigation that are strategy and legal issues that I don't even talk to my clients about. That's why you hired me, because I'm an expert in this field, and that's what I do. But the one thing I can't do without your permission is settle your case. When and how much you settle your case is your decision and your decision alone. Next.
I do have another one from the chat here. Joanne Johnson is asking, how long does this process take?
Okay, Ms. Johnson, so some lawyers may say how long it will take and give you some estimate. It's impossible for a lawyer to say that at this junction. I've had mass torts settle about 14 to 18 months after filing. Most mass torts do not end until after the statute of limitations. The statute of limitations is this. In a case like this, you have 2 years to bring your lawsuit. If you don't bring your lawsuit in 2 years, you're barred from bringing it. What defendants do is they sit there and they wait for that 2 years to run because they don't want to settle cases, give people an incentive to then bring a case before the statute of limitations. So it's likely this case will take 2 years or slightly more. But the lawyers will be doing work. Often settlement discussions begin before that, but defendants are very leery of settling it before them. I don't know what MGM is going to do. They may crater under the pressure. They may want to take responsibility and move on for this. I hope they do. They do have responsibility. But if they don't, it'll be 2 years and 1 day or thereafter.
All right, and thank you for the question, Joanne. If anyone else has questions out there, you can feel free to drop it into the chat, and we'll try to get to it. So what else would a person have to do before the case is resolved?
Okay, this comes up a lot. You know, I have the clients say, listen, I have my own life. I have my family, I have my work, I'm going to school. Everybody has their own life. So when you hire a lawyer, you want to know that they're handling the case and doing everything they're supposed to do. But the big question is, what do I have to do? Well, initially in the case, if you're with a lawyer like me that's going to be proactive, then you have to give me some information. You have to collect some documents. You got to collect some medical records. You have to give me information about yourself and what happened to you. That usually takes, a month, 2 months, 3 months for me to get that into the database. I have people working around the clock to do this and help folks around the country. After that, you really don't have to do much. You have to read my emails that I send you. Stay up to date on the case. If you have a question, ask me the question. I'll give you an answer. If you have an injury, continue to do your medical treatment and send me your doctors that you go to so I can get your medical records. But really, it's fairly hands-off for the client because we're going to be doing the heavy lifting. And when we need information from you, we'll ask. But maybe in 2 years, you'll put 20 hours into it total, maybe. That's if you have to give a deposition. That's about it. And it really should be that way. The lawyers should be doing the work.
So, Chad, is this going to be in federal court or is this going to be in a state court?
Like a state court case. Okay, this is not a class action that can be in federal court. There's certain defendants that allow us to keep it in state court. So I have little doubt that this is a state court action that will remain in the state court in Clark County, Nevada.
Okay, so we're dealing with a state court action. But will this be one big trial, or is this going to be split up into multiple little trials?
Okay, so in a mass tort, everybody has the right to have a trial. Usually what happens is the judge says, listen, we can't try one at a time. This will take forever. So sometimes they try 5 or 10 or 20. I've seen as much as 25 in a large case, because what we want to do in a trial is get a good perspective of what a jury might do in the case when they render their verdict. I very much hope I get to try this case. I don't know if MGM and the other defendants are going to let me try this case, but it's going to be between 5 and 25 plaintiffs in the first one. And then they set another trial for 5 to 25 plaintiffs in the next one, and so on and so forth. But each trial is a full-on trial. It'll take, 4 to 8 weeks to finish the trial. So it's a big trial, and it's going to have a lot of data and evidence and witness testimony. And then we'll wait a period of time and then try the next group if necessary.
All right, thank you for that, Chad. From the chat here, I do have another question. It's asking, in this type of case, do we have to prove that we were inside the event?
Okay, so it's a very good question. So the question involves a claim of negligent infliction of emotional distress. Now, I'm assuming if you had any physical injury, then you have a case. If you had a physical injury, running, jumping, getting shot, any of those things, you absolutely have a claim. So you're talking about a negligent infliction of emotional distress. That means I was there and emotionally I'm traumatized and I have to go to the doctor, and I may have to go to the doctor in the future. I may be off work now, I may be off work in the future. That's that PTSD claim. There is no rule that says where you have to be for a PTSD claim. Now, if you're inside the venue, you certainly have a claim. I mean, the police report said everybody in the venue, that 22,000, they're victims. If you are a victim, you should do something about it. You have a civil lawsuit, you were hurt and harmed, you should bring that case, and you should stand up for your rights and explain to these defendants, hey, you harmed me, you owe me. But let's just say you were outside of the venue. You still have a case. If you were seeing or hearing bullets go over your head, you were seeing people run, you were running for your own life, that emotional stress, if you had emotional distress, that is the claim. So it doesn't really matter where you were. You have to be in fairly close proximity. I mean, if you were miles away, that's not going to hold up. I'm sorry, but that's not going to fall under the claim. But if you are in close proximity, you have a claim. Fear for your life. You're having fear now. You have a claim.
All right, thank you. And thank you for the question. If anyone else has questions, you can drop it into the chat here, and I will try to get to it. But to keep moving along, I just want to know, basically, has the case been filed yet?
Well, there's been multiple cases filed by multiple different lawyers. Most lawyers have dismissed their cases and will refile. Last week we had a big meeting as lawyers, about 45 or 50 lawyers showed up in Vegas to talk about the case on the plaintiff's side of the bar, recognize who's going to be taking the leadership, and then talk about strategy. Of course, I'm not going to talk about anything we discussed in that room, but the important thing is that everybody came together. We're likely to start filing suits soon. After you start filing suits, then the master complaint will be done. But really, for a complaint that we're going to move forward with as a steering committee and trial group and trial lawyers, that one has not been filed. And a lot of the other cases have been dismissed, but those filings will come in. All the other lawyers will file their cases individually. Then we'll come together with a master complaint for which the defendants will answer.
Thank you, Chad. Is it too late to file a suit? Is there a cutoff point?
Yeah, well, there is a cutoff point, but it's certainly not too late. This happened October 1st, 2017, so you have 2 years from that date to bring your claim. But the truth is, the longer you wait, the worse your case is going to be. The lawyers need to start working on your case immediately. They need to start gathering evidence. We need to start gathering your medical records. We need to start forming opinions about your case and you telling us your story so we can understand it. The longer it goes, the less you remember. The longer it goes, the less a lawyer can help you. So if you're thinking about bringing a suit, call a lawyer, hopefully a good lawyer, one of the 4 or 5 law firms that can really handle this case. I'm one of them. Or you can call someone else. I'm not going to toot my own horn, but if you're going to ask me, I think I'm the best. But there's other people out there that are very good, and they're probably going to say they're the best. But get with a good lawyer, listen to what they have to say, know what your rights are, and then bring the case if you feel comfortable with it. As soon as possible. Don't wait. I mean, there's no reason to wait. By the way, if you don't like your lawyer, you can terminate your lawyer and you don't owe the lawyer anything. So if you get involved in the case and then you say, you know what, I don't want to do this, you can terminate the case. I mean, we take the risk for you. We pay the expenses. We take the risk of winning. That's what a plaintiff's lawyer does. We're willing to do that, but we know that you have the decision to bring your case or not bring your case. All right, Joey, I went on a little bit about that.
No, it's okay. We appreciate that. I do have another question here from the chat. It's, what if I haven't completed or submitted my information requested from your office just yet?
Okay, so no direct questions from my clients directly to me, but let me answer it this way. A lot of lawyers are asking for information from their clients because you're supposed to learn about your client's case individually. Really, you've got time to get the lawyer that information, but the faster you get it, the quicker we can work on your case, get it into the database, learn about your case, give you feedback about your case. So any delay is delaying your lawyer, and you don't want to do that. So if you can get it as soon as possible, that would be best. We're certainly going to be working on your case for a long time, but any delay is a problem for the lawyer. I would not delay that.
Great. I think we're about to wrap it up here. If we didn't get to your questions, you can go ahead and continue to add them into the chat, or I know there is an email that Chad has that you can send to it. Chad, what is that email?
It's Las Vegas at chadpinkerton.com. I almost said a different email. Las Vegas at chadpinkerton.com. Call my office, 713-360-6722. I appreciate you signing in. I'm trying to do this weekly to educate the public and let people know that they can bring claims and understand the litigation and really just keep this in the eye of the public. I mean, the media was here for 7 to 10 days talking about this case and it's gone. And that's not right. We need this in the public eye and public scrutiny so people can keep hearing this so they understand that companies like MGM and Mandalay Bay need to do something different in the future. Thank you for turning out. I'll see you next week, probably 8 o'clock, but I'll do a promo.